Good afternoon, and welcome to both our in-person and online audience. I'm Eric Anderson, and I'm part of the studio team. I have a few housekeeping notes before we bring out our distinguished guests. The Harvard Chan School hosts a diverse array of speakers. They do not speak for the school, and hosting them does not imply endorsement of their views, organizations, or employers. This is a live webcast and being recorded. We ask our in-person audience to take notice of the doors. In the event of an emergency, calmly walk through the nearest exit, and please silence all cell phones and devices. Okay, and with that, please join me in welcoming Dean Andrea Baccarelli and Justice Stephen Breyer.
Good afternoon, everyone. My name is Andrea Baccarelli. I'm the Dean of Faculty here at the Harvard THN School of Public Health. And I'm incredibly delighted to be here today with retired Justice Stephen Breyer. Thank you for being with us.
Thank you for inviting me.
And thank you to everyone for being here, whether you are in this room or anywhere else in the world watching us online. So I don't think Justice Breyer needs much introduction, but I would love anyhow to go through some of his biography. Not only Justice Breyer has had an extraordinary legal career, but he has also many past and present connections to Harvard. He graduated magna cum laude from Harvard Law School in 1964. He served on the Harvard Law School faculty from 1967 to 1980, and also held a joint appointment at that time at the Kennedy School. In 1994, Justice Breyer took his seat on the US Supreme Court, where he served until recently, until 2022. During that time, he heard numerous important cases that have impacted public health, and we are particularly interested to hear about that, perhaps, including decisions on the Affordable Care Act, voting rights, abortion, and the environment. After retiring from the Supreme Court, luckily for us, Justice Breyer returned to the law school here at Harvard, where he's now the Byrne Professor of Administrative Law and Process. And particularly interesting is that, as he just told us while we were waiting to come in, he has time to teach and to write. And he's just published a new book, which is Reading the Constitution, Why I Chose Pragmatism, Not Textualism. And we will hear more about that as well. So right now I would get started with our conversation. And I don't want to take for granted that all of us understand what's like to be a justice in the Supreme Court. So what's that like? What do justices do?
I have to be careful. I don't want people to have the impression they don't do anything. But I was a judge for 40 years, 12 years here in the First Circuit, and 28 on the Supreme Court. So what did I do? Go in your office, you get briefs. Those are the arguments, the parties, this side or that side. They're in little booklets. They're called briefs. Why do they call them briefs? They're not brief. And we read them, we answer questions. But what I tell the students who have to know, I want the students to know in the 8th grade, the 9th grade, they're 14, 15 years old. They've been told I'm going to tell them something interesting. So what they're all doing is looking out the window. So how do I deal with that? As you well know, talk to high school students or grammar school students. The ice cream truck is going by, sorry. So I say, here is what we do in an appeals court or the Supreme Court. I read it in a French newspaper. There was a teacher, a professor in the lycée, and he's traveling from Nantes to Paris. And he's a biology professor. And he has in his basket, a little wicker basket, 20 live snails. All right? So the conductor comes up and says, "What's that?" and looks at it and says, "Do you have a ticket for the snails?" He says, "A ticket for the snails? Are you kidding? What are you talking about?" He says, "Read this, the fare book. No animals on the train except in a basket and half-fare ticket." He says, "They're not talking about snails. They're talking about dogs or cats or maybe a rabbit." "Is a snail an animal?" No, I say to the students, now by now they're sort of interested. So I say, "Well, what do you think?" And at that point, I don't have to say another word. They're in the biggest argument you've ever seen. "Well, what about a mosquito? Is a mosquito, you have to buy a ticket? Is a mosquito an animal?" It says an animal. So I say after about 5 minutes, "Now you understand what a Supreme Court justice does." You got it. There it is. It's either in a statute or it's in the Constitution. They're words. And what do those words mean? What's their reference? What do they refer to? If it says policeman, does that include a German policeman? That's what they do. The words might be the freedom of speech. The words might be right to bear arms. But I haven't yet run into animals, but it could be. It could be. Now you understand the job. That's what we do. All right?
That's the clearest explanation I ever heard about someone's job. So let's turn to some current themes. And of course, many of us have been up all night last Tuesday, or not, and have in their mind the elections. And in your book, you quote one scholar, the constitutional scholar Paul Freund, and saying that the Supreme Court should never be influenced by the weather of the day, but will inevitably be influenced by the climate of the era. Particularly for me as an environmental health scientist, the idea of climate and climate change resonates with me. So what do you think of these results say about the climate of the era? How do you think it may or will influence the court?
That is the best explanation of the relation of politics to judges, Paul Freund's explanation. And one of the great things about it, nobody knows what it means. Absolutely perfect. Because when I go through the long explanations of what we do, you just got the very short version. The long explanation, it takes a while. I go through. Then somebody will say, "That's all." They don't say it in these words because they're more polite, but they'll say, "That's a lot of rubbish, isn't it?" It's really just all politics. I say, "No, it isn't. No, it isn't." Oh, say, naturally, you would say that. You want to protect your colleagues. No, it isn't quite that. There's a lot of politics involved in getting a justice of the Supreme Court appointed, and maybe any federal judge. There are groups that look all over the country to find a judge. What are they looking for? They are looking for a judge whose view of law, jurisprudence, how you decide cases, what the right approach is. A judge whose legal views are such that probably they think the results will favor our political views. That's different. The president is a political officer, and he is influenced by that sort of thing, and he should be in a democracy. But when you're at the end of the case, or in the middle, or at the beginning, talking to the judge, he really thinks he's doing it in accordance with his view of how law should and does work in this democracy with this Constitution. He doesn't think he's doing it because of politics. Now, why do I hedge? I hedged a little. Because if you really want to go into the subject, you think they really want to?
Let's see.
Okay,
Do you want
yes.
to go into the subject or not?
All right. Here's what. Do any of you read P.G. Wodehouse? Do you know who that is? Say yes if it's yes. Okay, great. It's very funny. It's very good. And one of his great lines, and this has always struck me, that's what the Supreme Court is like. He says, Bertie Wooster, who's the hero, Bertie Wooster woke up one morning and he wasn't disgruntled, but he wasn't exactly gruntled either. You see? Okay, that's why I have to hedge a little bit, is I'll say, look, here you are. First of all, at the moment, and that's why I wrote this thing, it isn't as long as it's looked. The pages are quite thick. but because there is this thing coming up. When I was in law school and thereafter and so forth, you have difficult cases. When you have a difficult case, you look, why did the Congress pass this law? Why? What was their object? But this thing came up called textualism or originalism, which says, don't ask those kind of questions. Just look at the text. And I say, just look at the text? Yeah, just look at the text. We promise you, if you just look at the text, you will discover what? First, it's easy. You just read the words. Second, it'll be the same across the country. Third, Congress will know what they're getting into because they know what will happen to the words they write on the pieces of paper. And fourth, you won't have these judges substituting what they think is good or good social policy for the law. So I say thank you for the promises. That's what I say in this book. I say thank you. Those promises are just great. But really, it's a little bit subtle, but not too subtle. I say you won't be able to keep one of them. There isn't one you can keep with that theory. First of all, you're going to say, here we have a case. What's the case like? Many of you know that if you have a child, a sad situation, and the child has some mental problem or physical problem, it's handicapped in some way, is a problem, the school board has to have special education for that child. Now, if you, the parent, don't think they're doing enough, you go into court, you sue under a federal law. If you win, and this is the, you'll see, if you win, it says the parent gets, are you ready for the word? Costs. Costs. So the case we actually had, the woman had won. She got better education for her children, and she said, I would like the cost that I used to pay the educational expert. $29,000. And the other side say, but you don't have, this doesn't give you a cost of educational expert. What, it gives you the cost of the lawyer, or it gives you the cost of the court. So which is it? Does cost include court, lawyer, educational expert? So I go to my friend, the textualist, and I say, what am I supposed to do? He says, just read the word. I say, okay, I read it, cost. No, you have to read it carefully. I say, okay, carefully. Cost. Or maybe I read it several times. Cost, cost, cost. I said, that isn't going to help, you know. And the cases that get to the Supreme Court are the main reason the case goes to the Supreme Court is because in the text of the law or in the text of the Constitution, different judges in different parts of the country have decided the same legal question, but different ways. And we're there really to make the federal law uniform. And of course there are difficult cases. And very, very few are going to be answerable by just reading the words, in my opinion. And I only have 300 pages of argument to say my opinion is totally right and the others are wrong. Okay, but you see the point. You see the point. These are difficult cases, so they say, what do you look to? And I say, well, you look to see what Congress was interested in. Read the reports. They won't always answer the question, but sometimes they will. They'll tell you what the object is. And also remember, when you do this, see what the consequences are. This has something to do with it. And you might look at this document, the Constitution, because it has in it certain values that this country has long thought, described, basic values of the country. And don't get too far away from those either. Now, those things don't work in every case, but they are traditional, going all the way back to John Marshall. And I say to my friend, yeah, the textualist, you see, I think you're going to have to go into the older system, which is going to require you to do more than look at just text. But by the way, I was explaining politics. And what he's doing there is he's using a system of looking at text. When the word originalism is there, when you see that word, that really means look at text. But if you're looking at text in the Constitution, it's pretty abstract. So Scalia would say, go and look at the text as it was interpreted and understood at the time it was written, say 1789. Or 1865 or something, or 1868 or whatever. But it's words, text, and I'm saying no, no, no. And that is the, politics? No. They'll come back to me and say, it was text we used. Or every person in this room has had years of life in this world. I grew up in San Francisco. I went to Lowell High School, state school. I went to Stanford. I did go to Harvard, and I did learn something at Harvard. It's interesting.
Some do.
Yeah, some do. That's good. That's good. All right, good. But now, you see, we've had the life we've had. I've had the life I've had. And that will affect your views. There is no way you can get out of it. You can try. And people do try, and judges try particularly hard. Try to set anything that counts as a personal view aside. Try to do this under the law. You cannot succeed 100%. That isn't really politics. This is being a human being. But it's there. And sometimes they've taken political science courses. And that sounds like politics, though it isn't. And then we have Paul Freund. Now, remember now what you said about Paul Freund. He said, no judge will decide a case according to the temperature of the day. But every judge is aware of the climate of the era. You see? Yes. Is that true? Yes, I think that is true. And you say, well, how does that? And Taft, when he was Chief Justice after he was president, wrote to Sutherland and said, I hope new appointments are people, they have to know some law. You know, it is a legal job, I hate to tell you. But they have to know law, but they also should know something of the higher politics. Ah, the higher politics. And just what is that? And I can tell you that when I was on the Court of Appeals, I didn't feel any pressure towards what the average person thinks or whatever. Politics in any sense, but on the Supreme Court, no, don't take this as too overstated. I have to be very careful how I say this, because I don't want anyone in this room to feel they've learned something. Because one of the most difficult problems is, well, to what extent do you pay attention to what the public is thinking? I bet there's not one of you here who would like to have as a judge, if he were ever, or a friend were ever, and she was in some kind of case, real trouble, criminal case, you wouldn't want that judge to be looking over his shoulder at what the public thinks. That person may be very unpopular. Of course not. But, and now you can substitute in your own mind, fill in the blanks. And now, when you try to weigh and try to figure out, well, what extent is it? Well, you can't say 0, but be careful. Don't go too far on this. Frankfurter says to the conference, when they had a case, miscegenation, Virginia said that was illegal. The court was going to say, it was soon after Brown, it was about 3 years after Brown, the court was going to say, of course it's illegal. You have to allow that. But, Frankfurter said, if we do this, the South will not follow Brown. I mean, this is 3 years after Brown. You know what happened the first year after Brown? Yeah, silence is the right answer, because nothing happened. and what happened the next year? Nothing. And it took quite a few years, and 1,000 troops from Fort Bragg flying to Little Rock, and my goodness, You see, you're not old enough, most of you, unless you're, I mean, all of you probably. But I mean, I can remember, it wasn't really till Martin Luther King came along, till Rosa Parks, till the Freedom Riders came in, when the North woke up to what had been going on in terms of discrimination in the South. And then things really began to change, but that took a long time. It took a long time. And so Frankfurters saying, foreseeing this kind of thing, don't decide this now. They did decide it right then, but 2 or 3 years later. And they said it's unconstitutional, of course. But you see, now is that politics? Yeah. But it was politics in the cause of seeing that Brown ending segregation in the South, they hoped, would actually begin to take effect. So, I mean, I can't say zero, so I quote Paul Freund, just as you did.
Yep.
Yeah, and then you say, well, what does that all mean? And I say, read Taft's letter. And you say, what are the higher politics? And I say, read Paul Freund. And then, perfect. And then by then, we hope the people that I'm talking to have begun to think of some other subject.
So can I push you just a little more? I mean, all of us who don't see the inner workings of the Supreme Court and might be reading the New York Times, the Wall Street Journal, the Washington. I mean, I confess I usually read the sport page first. So I mean, that is really, then I get to the real stuff. But when I don't read the sports, we get them, not to mention if we are on TikTok, on Twitter, on social media, we had this feeling that the Supreme Court might be very political.
Yeah. But I tried to explain that. It's not, look, I worked for Senator Kennedy for several years, all right?
Correct.
In the Senate, Ted Kennedy. But politics? Suppose Senator Kennedy gets a call from the Secretary of Defense, and instantaneously another call from the mayor of Worcester. Which will he answer first? Well, that's obvious. That's the most obvious thing in the world. He will take the call from the mayor of Worcester. That's where the constituents are. I mean, of course he will. I go into my office one day, and there's a young woman who is going through every paper on my desk. Someone I didn't know. So I said, excuse me. How do you happen to be going through every paper? He says, well, I was curious to know what the Council of the Judiciary Committee did there, and I thought a good way would be to read all the papers that you have on your desk. And I said, oh, I see. And so I became about to be a little sarcastic, about to be a little annoyed, about to be a little angry, and then suddenly this thought entered my mind. Perhaps she is a constituent. Now we have politics. Are you popular, unpopular? Is what you're going to do written well in the paper? How do people react to what they read in that paper about what you did? Are you a Democrat or a Republican? Can I get some of the Republican senators please to come to some of the executive sessions? How do we do all that? That's politics. I have not seen that in the Supreme Court in 28 years. When we're in our conference discussing the cases we have just heard, you go around the table, everyone has a black book. The black book has for every case the name of all the other justices. We go in order of seniority. No one speaks twice till everybody's spoken once. The Chief Justice says in about 5 minutes, we just heard this week the oral argument in such and such a case. I think tentative, but that's what I'm thinking at the moment. And then it goes to Clarence Thomas, and then it went to me, and then it went to Alito, and then to Sotomayor and Kagan and Gorsuch and Kavanaugh and Barrett. And now Ketanji. And she was my law clerk, so and then we have some argument back and forth. But now the argument's important because nobody speaks twice, remember, till everybody speaks once. And that's a very good rule, particularly for a small group. And it was helpful to me because I was last. I was the junior justice. I was appointed last, you see. I was a junior justice for 11 years. And I missed the world record by 11 days. And I thought of writing to Sam Alito, who was the next justice to be sworn in, and I was going to say, dear Sam, will you please wait 11 days? If you will only wait 11 days, I can go down in history as the answer to a trivia question. But in any case, that didn't work out. But then after you go around once, then back and forth. Now, this I think is useful, because I learned pretty quickly. If when I listen to somebody else, I can write down what they say and so forth, and I start to make an argument, and the real point of my argument is, it doesn't sound that way, but they know, ha, 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 I have a better argument than you. That immediately will get me nowhere. Because all it will do is produce in the person who thought the other thing, ha, 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 I have a better argument than you. And that gets you nowhere. But if, on the other hand, you try to see where they're coming from, and that used to work in the Senate pretty well, try to see where they're coming from. What is it that's bothering them? What can you say that, given that point of view, can help bring several people to agreement, maybe not perfectly, but maybe better than nothing? What that kind of an argument will, at least sometimes, change minds. Not change from A to B, not A to minus A, but A to maybe B plus, or A minus. And I've seen that so often that when I describe the conference and those books that we're writing down, what I say is it's very professional. I've never heard a judge in 28 years in that room raise his voice. It doesn't happen. I have never heard one judge say something insulting, not even as a joke, about another. I say it's professional. People are listening. They do not always agree. They are unanimous about 40% of the time. That used to be true. 5-4, this used to be 5-4, the press would say, conservative, liberal, or whatever they want to say. But the 5-4, 5% of the time, 10, 15, probably more. I counted it one year. I counted it. There were 18 5-4 cases, okay? 12 of them were different groups of 5-4.
Yep.
And I thought every time, I didn't check it, so I may not be right, but I thought in every one of those 12, the press will write in an unusual concatenation of people. I said, how can it be unusual? It's the majority. but nonetheless, it's, look, I mean, it's not this tremendous fight over everything, but you're getting in the papers are the things that interest people to read. And what interests people to read are things that do verge on the political or the social or the tremendous war, but that isn't basically what the court does, nor necessarily what it's always there for. Sometimes, but less than people think, less than people think. And I'd keep that in mind when you read these articles. And I'd keep in mind, too, another thing I say to those 7th graders. I say, look, I was at Yale when I said that. I said, I'll tell you in a minute. But I said, you know, where do you think, what city, if you're from California, what is the city where most of the law that affects you and your parents is made? What city? Anybody know? Yes, correct. You know, see, you teach them everything at this School of Public Health. It's fabulous. But an awful lot say Washington. No. Margie Marshall, who was Chief Justice here, and she looked it up, and she said there are 45 million cases involving state law, and maybe only 1 million or less involving federal. Almost all the law is made in states. In Boston, when I was in Yale, there was a Chinese delegation, and I said, in Connecticut, it's in Hartford, and people in Washington want you to think that that's the most important. Well, it isn't. It might be. I'm not saying they do unimportant things, but no, it's not that there's some most important in Washington, less important. No, that's just not how it works. And so I want to say this to the 7th graders, because I want to say, if you want to help your family, if you want to help your neighbors, if you want to help your friends, and those who are not your friends too are very often deserving of help, fine. Go to Sacramento, San Francisco, go to the city, the town, not just Washington, D.C. Please, please. And that is, yeah, in Yale what I did is I said most of the law is made in Hartford, which I thought was the capital of Connecticut. All right, so at the end, at dinner, they asked the Chinese delegation, is there anyone with any questions? And the head of the delegation said, we do have a question. And they said, what is the question? He says, why is all the law in the United States made at Harvard? There we are.
As a segue to what you just said about disagreements or agreements in the Supreme Court, we at the school have been working about how to build skills that help us to talk and discuss across differences of opinion, backgrounds, or any type of differences. So based on your experience, and you probably touched upon a little bit, what are the skills that help creating an environment like the one you saw in the Supreme Court, or even better if we can?
Well, that's what I learned. Again, we're back in the 7th grade. I mean, they say they're back at the window. But somebody will ask me, how should we interpret the Constitution? The first thing I say is, my friend, this is no longer my document, it's yours. It's held us together, 330 million people, with the one civil war and slavery, and God only knows what. But it's held 330 million people together since, almost 250 years, all right? 330 million people, every race, every religion, every point of view imaginable. My mother used to say that in San Francisco. She would say, there's no point of view so crazy that there isn't somebody in this country who doesn't hold it. And then she used to add, don't tell anyone I said this, but she used to add, they all live in Los Angeles, she said. but that's what it is, and it does hold us together. That's the most remarkable thing that I see in the 28 years sitting there. I think there have been mistakes in the Supreme Court, there have been, of course. But it's also, there have been some good things. Brown versus Board is a pretty good thing. And I don't know if anything would have happened without the court there. And I can name some pretty bad ones too. But that's the world. So what Kennedy used to tell us, and I learned a lot from Senator Kennedy, I learned a lot. And he'd say, look, to the staff, don't worry about credit for something. We're trying to get some bill through, or we're trying to stop a bill or something, and we have people who disagree with us. The first thing you do is find somebody, and John Stuart Mill said this, find somebody whom you believe is intelligent and who thinks the opposite that you think. You find this person and you talk to them. Wait! Don't talk too much. Listen to what they say. And if they talk long enough, they will, in all likelihood, say something that you actually agree with. At that moment you say, oh, what a good point you made. And we try to work with that. And let's see if we can. And sometimes you can't. And he would tell us, if you get 30% of what you want, take it. Take something that's better 30%, and to hold out for 100% so all your friends and followers will say how wonderful you are, a person of principle. The world is just as badly off as if you got nothing, because you got nothing. And I saw him, he didn't just say it. I mean, when we got something, the press would ask him, he'd say, Senator Kennedy, you did such a great job here, it was great. And he'd say, don't thank me. Thank Orrin Hatch, the Republican, who came up with something that led us to a kind of compromise. Not perfect, but better than nothing. All right, so when I'm telling that to the 7th graders, it isn't just what I told them that I think is so great. It's the fact that they're no longer at the window. It's the fact that they've come in and they're listening. And I'd like to think, maybe I'm making it up, but I like to think by the look in their eyes, they're actually interested in this. They're actually seeing something they can do in a country where people think very different things, but something they can do to sort of help with the problems that are in front of us. which we know perfectly well, the environment, you have all the diseases in the world. In Africa, you're trying to do something about that. You're trying to do something about problems of hunger. You're trying to do something about problems of, well, you name it, of the fact that we're technically capable of building I don't know what, but we have a hard time distributing it so that people don't feel very poor in some places. And, well, you know all those problems. And those problems will not and have not gone away. And so the question is, what do we do? And the answer is not, this is what I told my granddaughter, who was I told her, she said she didn't want to go see X, and X was a person who voted for somebody she wasn't too happy with. All right, so I said, really? I said, so what are you going to do about that? What are the most, I asked her this, could she study a little? I said, what are the two most important words in the Second Amendment? I'm not expecting you to know that. The Second Amendment says a well-regulated militia being necessary for the security of a free state, the right of the people to keep and bear arms shall not be infringed. I like that because I know she didn't like the court opinion in that. I didn't like it too. I thought I wrote a dissent that proved it was totally wrong, and it did prove it was totally wrong to me. But there were 5 people who thought the opposite. Okay, but I said, okay, what are the most important words? I just read a book which said the 2 most important words in that Second Amendment are these 2 words: free state. What's a free state? There are a lot of people, certainly since mid-19th century, who think those words mean the government can't tell you very much about what to do. Yeah, some of it means that, some of it. But that's not the whole story. Ever since the Greeks and Pericles and everybody else there went to the Agra or wherever they went, it also means the people within limits that are in here, but the people will decide what kinds of cities, states, country they want. And I said, and what's the mechanism through which most people do that decision making? And she got that, figured that. Vote. And I said, fine. Everybody votes. Good. The more that vote, the better. Fine. That's called democracy. But suppose you lose. What do? I said. You go under the bed and cry. I worked for Arthur Goldberg. I was his law clerk, 1965. He would say when we came in and lost a case, and I would say, but we were so right. He said, you want me to cry? He said, what you do, I said, get out from under that bed and go find those people whom you disagree with. And find a few of them who work together with you, not on politics, but on the problem. The problem called the environment. And it's not impossible, but it's difficult. Okay. So she said, I see your point. I'll go phone my friend X. Okay, I see the point. All right, but in any case, that is, well, I mean, I've seen that in the, maybe I'm overly optimistic, but my God. You were here during COVID in Cambridge, Mass., which I agree is a different place. In Cambridge, Mass., I saw groups of people, some of whom I knew, go around to old people's houses and say, are you okay? Do you need any food? I've seen people do the same thing, or heard of them do the same thing in San Francisco, San Diego, you name it. St. Louis, I don't care when. Americans are not so bad at getting together. They're not so bad at it. That's what I learned in the 5th grade. I mean, not exactly. Mrs. Squataquatza. She would assign a project to a group of 4, and she would say, you're going to get 1 grade. I mean, that really forced attention to be paid to others in that group. Well, that's how we used to work at grant school. Good. All right, well, you see the point. But I've seen that for 28 years, and I can't say it's always worked out well, and sometimes it's worked out very badly. But I think it helps. Helps us get somewhere, that 30%.
Can I follow up on that? Because I wanted to ask you, I mean, the Supreme Court or the judicial system in general often deals with cases that have to do with public health. Let's take an example of a recent ruling on the on the limits of the EPA and the environment. And here at the school, we do a lot of science and we have a lot of expertise on how air pollution, for instance, affects health. So, I mean, in your role as a judge, or in general in the judicial system, how do you interact with scientists? How do you interact with practitioners who may be in the world?
They'll file briefs. I mean, if it's really a serious public health question, there will be all kinds of these little documents. You see what we get in a case, blue brief, the court below is wrong. Red brief, no, it's right. Yellow brief, I told you before and I'm telling you again, it's wrong. I always read the yellow brief first. It says the same thing, it's shorter.
Okay.
And the light green briefs. Anyone, you can file one. Why they're right on the blue side. Dark green, why they're right on the red side. And they're usually in a case, maybe total number of briefs, 15, 10, 15, sometimes more. Right to die case, there were 100. Affirmative action case, there probably were 100. We couldn't deal with 100 all the time. But we can maybe once in the year or so. So you read. And do I read all of them? I try to read all of them. All right. Well, when don't you? I don't read them if I start going through it and I see it's just repeating what's before. If they're telling me that the union, or say the Chamber of Commerce, is in this side, I say, oh, that's interesting. I can read that in 2 seconds. It affects nothing. When I see a good legal argument, in the case that I liked very much because I knew nothing about it and I really had to spend 2 years learning about it, was a case about Java. Mm-hmm. Not Java the country. I didn't even know there was anything besides Java the island. But there is. It's called a computer language.
Yep.
And I had to spend a long time trying to figure out what was going on. And we had great experts. Mitch Kapor is supposed to be a great expert, invented Lotus. And he filed a brief. And so we'll get these briefs. And sometimes, if necessary, we can go, the library can set up some kind of exhibit so they can explain to us what the thing is. So people know it fairly well, but it comes not perfectly. But there will be experts in the court below. And there are methods for a district court, or even a court of appeals, and we could possibly, we don't usually, hire, ask the parties to pay for a really good expert on such and such, so you have a record which makes that clear. All I can say is that case, it was, what was it? It was Oracle versus Google, I think. And it was a copyright case. It's very interesting if any of you want to give up public health. I mean, copyright is a great field. But in any case, it was a copyright case, and it really took us 2 years, and we ended up being unanimous. And I was curious. I don't usually do this, but I was curious to know what the profession thought, not the legal profession, the technical experts. I don't normally look, because they're going to say, some of them, if they want, agree or disagree, the judge is an idiot, or the judge, why do I have to read that? But no, they liked it. Then they didn't like it because they thought the result was right. Some thought it was right, some thought it was wrong. But they liked it because they felt that we knew correctly how this thing worked. Mm-hmm. And that's what we're aiming for. That's what we're aiming for, and that's what we do not always succeed at doing. And the answer is, if you're worried about what the others are writing on the other side in the briefs, you get somebody who will spend the time and effort to write. Eric Landers wrote a very good brief on a voting issue, where I think he'd read the other briefs and tried to explain how, mathematically, mm-hmm. Or what rule you could have that would resolve this in a satisfactory way. So the information tends to come in, not always perfectly, but it tends to come in.
That's really fantastic to learn. I've been learning a lot really today, but we have some more questions that were not prepared by us, but came from the audience. Right. So I'll read a few of them, if you don't mind. So the first question is from Nick, who is a Harvard Chance student. And this is, how do advances in the evolving fields of public health and medicine guide interpretation of a static document like the US Constitution.
Is it static? How static? I mean, the freedom of speech. The freedom of speech, does that apply to the internet? That doesn't sound static. Nino and I thought we were good friends, and Scalia, and we used to go debate these issues. And we were in Lubbock, Texas. I don't think they'd seen a Supreme Court justice, and we do look the same as anybody else. But they came to the football stadium. I think they thought a football game was going to go on. But they ended up, I'd say, for example, to say that you have to be somewhat aware of the circumstances called the era, which we talked about before. I would say, Nino, George Washington didn't know about the internet. And Nino would say, I knew that. Yes. And then I would say, and he'd say it's like this. And this is serious and rather deep, what he said. And he said, it isn't the problem. I know my system, which is more originalism, textualism, et cetera. I know that that system will not work perfectly. But it's like the two campers. One sees the other putting on running shoes, and he says, why are you doing that? He says, there's a bear in the camp. He says, yeah, but you can't outrun a bear. Oh, yeah, that's true. He says, but I can outrun you. Now, right. So I say, okay. Then he says his real objection to the way I go about deciding cases, which this is filled with, too complicated. People won't be able to do it. They will substitute their own views of what is good for what the law would require. That's why it's better to have a simpler system. And I would say, Nino, I understand your point, but I will tell you, in my opinion, if we follow your systems, we will have a constitution that no one would want. You see? Okay, who's right? Neither of us will really know. Neither of us will really know for years and years, and we won't be around. I think that the system, a system, what is it? It's what John Marshall said in cases that said this document has to last. It has to last, and you read that and say, 10 years? No. 100 years? Maybe. Maybe. And you read what those founders said. You read it. George Washington wrote a letter to his friend, and he said, this is an experiment, the United States of America. It's an experiment. Mm-hmm. And see, he's thinking the French Revolution is beginning to go on. And a lot of our ideas come from France, the Lumière, the Enlightenment. But those French people, I tend to think, don't say I said this, all right? I tend to think they're like Harvard professors. They have great ideas, but they don't trust Americans to put them into practice. So Abraham Lincoln says, and my wife said my grandchildren get $20 each for memorizing the Gettysburg Address. I heard it enough, some of them did. I said, 87 years ago, our fathers set forth upon this continent a new nation conceived in liberty and dedicated to the proposition that all men are created equal. They meant women too, I hope. We are now engaged in a great war to see whether this nation or any nation so conceived and so dedicated can long endure. Mm-hmm. You see? In his mind, it's an experiment. It's an experiment. And if there are any seventh graders left in this room or that room or wherever room I'm in, I say we're still in that experiment. We're still there. And since we're still there, I hope you will not go and hide in the bed anytime you lose, but you will rather seek out people who don't agree with you and see what you can work out with them, because the problems are going to still be there. They're still there. There's no question about the need to continue and continue and continue and continue to work on them with people who agree with you and people who do not. And I can go back as far as Lincoln and Washington and further back, because that is what the country is, and it is an experiment, and it is made up of every person under the sun, and they do have every point of view under the sun, and that's all true, and through some miracle, we've managed to stick it out. And so that's, I guess that's the message to the 7th graders and anyone else who prepared to listen.
I'm ready to go back on 7th grade myself. So but I think we made a small error in planning the event today. We really needed 3 or 4 hours because we had so many questions. And I know that we could have on for the entire day. But I have the very hard job to keep us on time. And so our time today on the stage ends here. And this has been an amazing discussion. All of us enjoyed it incredibly. So please join me to thank Justice Breyer for his time and for being with us.